Before 2013, a family lawyer's first client meeting rarely focused on how the case would be paid for. Public funding through legal aid was a default right, broadly accessible for most people navigating a divorce, a financial dispute, or a custody arrangement. The Legal Aid, Sentencing and Punishment of Offenders Act 2012, LASPO, removed that default right, replacing it with a restrictive, exception-based regime. As a modern practitioner, you are required to master both the strict constraints of this public funding system and the private alternatives. You have to know exactly how to navigate the statutory charge, as well as the rules for privately paying clients. To do this, you must rely on the funding matrix. It is a definitive decision tree that every family lawyer uses to determine how a case will be financed. Today, securing funding requires a complex statutory analysis that dictates whether your client receives legal representation. Cases start at client intake, splitting into public or private funding. The public artery hits the scope gateway. Standard cases, divorce, finance, private children, are out of scope. The path is blocked. However, the path remains open for high-risk categories, like public law, domestic abuse, and forced marriage. Public law care proceedings hold a unique status. Because the state is intervening to remove a child, parents are entitled to legal aid on a non-means, non-merits basis. There are no financial hurdles to clear. If your client has an out-of-scope private dispute, such as a child arrangements order, but is also a victim of domestic abuse, the Schedule I gateway exception applies. This allows private cases to be pulled back into the scope of public funding, provided you can produce strict statutory evidence. This cannot be a mere allegation. You must provide concrete proof, such as an official police record of an arrest for a domestic abuse offense or an active protective injunction. LASPO scope is a rigid binary. However, specific statutory evidence can make public funding available for private disputes if identified early in the intake process. Clearing the scope gateway only earns the right to be tested. The case must pass two secondary filters, the means test and the merits test. The means test evaluates eligibility through rigid capital limits. If your client has over £8,000, they fail and are ineligible. If they pass the financial check, the legal aid agency applies the merits test. This is the reasonable private paying person test. The agency asks, based on the likelihood of success and potential benefits, would someone spending their own money choose to fund this litigation? Passing both filters results in tiered funding. The entry level is controlled work, which covers legal help or family help lower. This pays for initial advice, drafting letters, and negotiating, but does not cover issuing court proceedings. To offer controlled work, the firm itself must hold a specialist quality mark. If negotiations fail and you must issue court proceedings, the case moves to licensed work, such as family help hire or legal representation. This tier requires a full, formal application to the legal aid agency for a specific certificate. Being in scope only grants the right to apply. Financial and merit scrutiny ultimately dictate the actual level of representation a client receives. Once legal aid is granted, you must address a critical area of professional liability, the statutory charge. In financial disputes, legal aid is a secured loan rather than a grant. By law, the legal aid agency must claw back its costs from any property or money that is recovered or preserved by the client during the proceedings. The agency recovers money sequentially, first from costs orders, then client contributions. If there's a shortfall, it attaches a charge to recovered property. In Morgan v. Legal Aid Board, a couple's compromise settlement couldn't evade the statute. The charge snapped on to their holiday home. Narrow exemptions exist. The charge does not apply to ongoing maintenance payments or pension sharing orders. If you fail to warn your client that preserved assets are perpetually vulnerable to this 8% recovery charge, you risk severe professional negligence claims. If a case is entirely blocked by LASPO and public funding is impossible, you must transition down the private funding artery. For clients who cannot afford to pay, the primary statutory tool is the Legal Services Order, or LSO, under Section 22ZA of the Matrimonial Causes Act 1973. An LSO orders the wealthier spouse to pay legal costs. Securing one requires meeting strict criteria from Rubin v. Rubin. First, prove absolute necessity. Provide documented refusals from at least 2 commercial lenders. Second, Obtain a formal refusal from the solicitor to enter a Sears Tooth agreement. Private funding via the court is a mechanism of last resort. It demands exhaustive proof that all commercial and contractual avenues are closed. When we look at the complete architecture of this landscape, the divergence between the legal aid agency pathway and the private pathway is clear. This dictates your day one diagnostic flow. Categorize the case, identify statutory evidence for domestic abuse, and establish whether the matter is in scope or out of scope.
If public funding is secured, your duty is to manage expectations regarding the statutory charge and the risk to recovered assets. If the case is out of scope, you must instantly begin assembling the evidentiary burden of bank refusals and solicitor statements required for a legal services order. Competency in this funding matrix is the requirement for practitioners to secure access